Welcome to Under the Hoodie. This is a series of podcasts where we go under the hood of some really interesting individuals from cybersecurity and data protection world, but also we go under the hood of some key topics as well. Now, I'm delighted to be able to introduce to you this week Carrie Bradley from AvatarIP Law. And we're going to talk about, or rather, she's going to talk about IP law. She knows a thing or two about this world. She's been involved in IP law and the legal sector since April 2019, I believe it was. And this episode is going to give you an insight into why the intellectual property law is such an important thing for you to think about. This is a episode which is, of course, for practitioners in information security and data protection. Is IP law and IP risk and copyright and trademarks, is that on your risk register? If not, well, spoiler, it probably should, and Carrie's going to tell you why. But it's also for business owners as well. And if you're looking to start a business, then you need to understand the importance of IP law and trademarks and copyrights and the such like. Anyway, again, as ever, I'm not going to get in the way of this. It's a great conversation with Carrie. I really learned a lot, as I always do whenever I speak to Carrie. So if you aren't connected with her, I would suggest that you do. I'll make sure the links are provided as part of this post. Enjoy, and yeah, you'll learn a lot. Speak soon. Carrie, thank you ever so much for joining us on Under the Hoodie. How are you doing?
I'm good, thank you. How are you?
I'm very good, thank you. So as you know, as I explained, what we're talking about here on Under the Hoodie is, or what we're doing on Under the Hoodie is we're interviewing interesting people, and also interesting people who have a interesting career and role to play in respect of information security, data protection, and privacy. Now, we've known each other for a little while now, and intellectual property is one of those areas which I think is shrouded in mystery for most people, and you've helped us understand it quite a lot, and consultants like us, thank you for working with us and working with a number of our clients as well. And you very kindly have offered to come along and do a little bit of a show and tell around this important topic. So I know you've got some slides, so I'm not going to steal your thunder. But yeah, if you could just talk to us about the myths around this topic and give us some tips as well.
Thanks, Gary. Thanks for inviting me to speak. Just to introduce myself to everyone, my name's Carrie Bradley. I'm an IP lawyer with 25 years experience now, and founder of a boutique little legal practice called AvatarIP. So I specialise just in IP law. And I'd like to start by asking you all a question, and that is how much money your business is losing without you even realising it. And I know that probably sounds a bit dramatic, but this video, it's intended to represent what it looks like to run a business with no IP strategy and no IP protection. So the reality is that your business is losing value, even if it's very quietly, it's constantly, and it's expensively. And most founders don't realize it until there's a problem. So I think IP has a massive image problem. And if you can all leave here with one thing today, just one takeaway, I would hope that it would be just the knowledge that IP applies to all. It's kind of a long-standing joke that people don't call me until there's a problem. And it's a bit like trying to get house insurance when your kitchen's already on fire. So usually it's, you know, when there's a copycat issue, or they're trying to sell a business and there's due diligence happening and there's a panic of, oh God, what about the IP? But IP should really be on your radar from the very conception of your business, ideally. But yeah, as I was saying, IP's got a massive image problem. Most people think that it just doesn't apply to them. It's just got no meaning to most people. I think that it's perceived as being something that only applies to big businesses with deep pockets, people that are in the cutting edge technology field or big pharma. So most small businesses and startups just don't think that IP is relevant to them. But the benefits of IP and all of the risks of IP law apply to everyone, whether you're a sole trader selling flowers on the high street or whether you're a large multinational company. So it's because of this lack of awareness and this perception that it doesn't apply and they don't need to learn about it that I see the same problems, businesses sort of falling into the same pitfalls over and over again. And they are all things that can easily be avoided with just a little bit of knowledge, and then just prevented completely. And sadly, it's usually quite a long way down the road before these problems materialize. And it's a bit like a slow plumbing leak in that it's just slowly rotting your foundations until a sort of crushing tsunami comes and knocks your house down, basically. So basically every business needs to care about IP. It's not a legal issue, it's a commercial issue. It's at the very core of your competitive edge. It's an evolving financial asset that is intrinsic to the long-term value of your business. So whenever you create something in your business, you are creating IP, and it's what gives you a competitive edge. And it's the protection of that means you maintain your market share. So it really is at the core of what makes your business money, and it's not just something separate that you can just choose to ignore. And it became very obvious to me quite early in my career that it's just not a level playing field, because all of these innovative startups and SMEs are just getting crushed because of all the ignorance. They're missing out on protecting or enforcing their IP that drives their growth. So they can't secure funding, they can't compete on an international scale and build long-term business value. So my passion really comes from helping small businesses realize the value of their IP and level up in the bigger playing field. So I thought, a fun way of kind of addressing IP would be to look at some of the most common myths that I hear in my day-to-day practice. And there's a lot of old wives' tales and myths and Chinese whispers about IP, which is where I think a lot of the misconception comes from. And quite honestly, a lot of the advisors that new businesses turn to for guidance in marketing, designers, accountants, business coaches, they are sources of misinformation too. So I thought a quick intro to the topic would be to just talk about the most common myths that I hear. And so I would say the first one is this, that my business doesn't have IP. So this relates to what I was just saying a minute ago about this perception that it just doesn't apply to them. But every single business has IP assets, and you're bound to have far more than you realize, whatever field you are in. I think when people hear the term IP, they generally think about patents, but IP is an umbrella term for lots of different rights which protect different things, often simultaneously. So they're layers of legal protection, like a shield, protecting you from copycats from whichever angle that they come at you from. Now, of course, every business is going to look completely different, but they should all be being identified, no matter, identified, protected, and then leveraged, whatever commercial field your business is in. So you might hear the term IP assets being thrown around. IP is just any intangible property or asset in your business. So whenever you create something original, you're developing IP, and it includes everything from the more well-known registered rights like patents and trademarks and designs, which all relate to brand identity and product or packaging. But there are lots of far more overlooked intangible assets like domain names, social media handles, confidential data, which is obviously something Gary can help you with, trade secrets, and all of the years of know-how that you have accumulated. And these are all the intangible assets in your business. And they're what give your company an operational advantage over a new entrant to the marketplace. And the more difficult these assets are to replicate, the stronger your competitive advantage. So they're the intellectual property assets. The intellectual property rights, or IPR, as you'll probably hear it referred to, they are just the legal tools that we use to protect the value in those assets that I've just mentioned. So rather than waste time sort of listing out the different types of IP and what they all mean, I think it's more useful to understand in a business context how they're relevant. So this is a real life example of IP rights in action. It's a client of mine, and they launched an all natural deodorant. And so the way that we've got sort of IP rights overlapping to protect this product is that the deodorant itself is marketed and sold under a snazzy brand name and logo. So they're all locked down with trademark registrations. The product packaging itself, it has a really unusual shape and appearance. So we've got that protected with a registered design. Photos of the products, all the marketing materials, they're all locked down with proper copyright notices. And the actual deodorant itself is made from this new all natural formulation. And so that is protected with trade secrets and know-how and confidentiality agreements. And the product itself is actually made using a new manufacturing method. And so we've got that protected with a patent. So if you think about this deodorant now, if you're a competitor and you want to try and rip this off, how are you gonna come at this? Because you can't copy the name, you can't copy how it looks, you can't copy what it's made of. In whichever angle you come at, we've got an IP shield to fend you off. And so what happens is if a product gets copied, then its value devalues because you can get a cheaper knockoff version, and the whole business position is massively affected by not having the IP protection in place. So another common myth that I hear is that IP protection can wait. So often with startups where, I get it, budget's tight, and so they're trying to prioritize any spend. But the reality is that IP protection should be done from day one, ideally. Many IP rights can't be acquired unless specific steps are taken at specific times. And so that's why it's planning and developing an early IP strategy is really important, because if you wait until a product's been developed and marketed, or discussions are already underway with an investor, then the chances are that you've already lost the ability to secure many critical forms of IP protection. So it breaks my heart when people come to me and say, we've got this product, it's selling really well, we want to lock down a design for it. And I go, oh, it's too late, because you've already revealed it to the public. So patents and designs both require novelty, which means for patents, no prior enabling disclosure anywhere in the world. With trademarks, some jurisdictions have a first to file system, so even delaying filing your trademark can have adverse consequences. But the point really is just that taking a delayed or piecemeal approach to IP protection can be the undoing of a business, just leading to a loss of their rights entirely. So all businesses, startups particularly, should be thinking about having an IP strategy so that you can budget and prioritize legal spend according to what matters when. A lot of things can just be handled with good internal processes, but some things do require formal registered rights that have to be applied for at certain times. So knowing what comes first enables you to prioritize, legal spend accordingly. Another fun one that I see is that most people don't understand the difference between the TM symbol and the R symbol. There is a big difference. It's actually a criminal offence to use the R in a circle. That means it's a registered trademark. The TM in a circle just simply means that you're indicating that you consider something to be your trademark. It doesn't mean that you legally have any necessarily, but most people recognize the TM symbol as meaning trademark, and so it can have a useful deterrent effect. But yeah, it doesn't mean that it's officially registered, whereas the R obviously signifies that it is a legally registered trademark with the appropriate authorities, which is why it's a criminal offence to mislead the public. Now, different countries have different rules. This is obviously UK specific. Most territories recognise TM as being unregistered, but that's not true for all. So this isn't generic advice. If you're exporting overseas, then you need to take specific advice about which symbol to use and when. Another one that I hear a lot is that people will ring me saying, quick, Carrie, so-and-so's ripping us off. We need to stop them. And I'll say, great, do you own the name? And they'll say, yeah. And then when it actually comes down to it, they own the limited company name for the name. And so they think that gives them exclusive rights to the name. And the legal reality is that it doesn't. In order to protect a name, you have to register it as a trademark. The Companies House register is literally just a list of legal entities. It's not a list of trademarks, and they go to great pains to stress that it doesn't mean that you've got any rights to trade under that name. So you can technically register any name you like with Companies House as long as it's not identical to a name that already exists. So even very minor differences can be sufficient. You'll probably be surprised. So, for example, I might be able to register a limited company name, McDonald's with a Z Limited. Does that mean I can legally operate as McDonald's? No, of course not. McDonald's are going to have something to say about that, aren't they? So having a limited company name does not give you the legal right to trade under that name or to own that name, essentially. So especially if it infringes an earlier trademark. The thing to remember really is that trademarks are the top trump card. They trump everything. So if someone comes along and registers your trademark within a limited company name, you can just apply to the company names tribunal to get them to change the name because you own the registered trademark. It trumps everything. It's the same with domain names as well. I often hear the same thing with people thinking that because they've got the .com registered that they own the name. It's not true. Another common myth that I hear is that people think, this one's a very common one, that if they've commissioned someone to create something for them, like a graphic designer creating a logo, for example, this is a common one, they assume that because they commissioned it, they own the copyright to it. And it's simply not the case. The default position in law is that the person who created the work is the owner of the IP, unless there is an express agreement in place which states that the commissioner owns the rights to any IP that's created from the work that's done. So usually copyright, unregistered design right, things like that. So case with people who create things as part of their employment, if it's part of the usual course of your duties, then it will automatically be owned by the employer in that situation. But yeah, it's something to be aware of. If you've commissioned anyone to take photos for you for your website or draft a logo for you or anything, make sure you have in the terms and conditions that they will assign the IP rights to you. But a little caveat, if it just simply says, upon payment of my invoice, I will assign the copyright to you, that isn't an actual assignment. That's just a promise to assign. So you still need to get a separate written assignment whereby they say, I hereby assign the following to so-and-so. So it's just good housekeeping, but trust me, these are just the tiny little things that you can deal with that can prevent massive headaches later on. My favorite example is a client that came to me with a logo, and she'd paid £10,000 to a designer to have it commissioned. It was a beautiful logo. But she went to a networking event and produced her business card, and another lady did the same, and she had the exact same logo, and it turned out they had the same designer. And when I looked into it, the designer had expressly said in his terms and conditions that he would not assign the copyright under any circumstances. And so neither of the ladies owned the copyright, and he was free to do it, sell the same logo over and over again. So it's something just to check off, be aware of and check it off. Another one that I hear often is that there's a kind of perception that if something, usually an image, is online, i.e. it's been published on the internet, then it's free for people to use, but it's not a free-for-all just because something is online. In the UK, copyright protection is automatic. You don't have to register it like you do in some countries like the US. So, and that is the case regardless of whether there's a copyright notice or not. So I mean, I would always recommend that you do display a copyright notice, but to put people on notice as a deterrent, but it's not legally mandatory to do that. I think where the confusion arises is because the legal term in the public domain refers to when the copyright protection's expired. It's got nothing to do with whether that material is publicly accessible, i.e. published online. And so I think that's where the confusion arises, because people think, oh, it's publicly accessible, so it's in the public domain. It's a different meaning legally. And since copyright, in a literary or artistic work is for the life of the author plus 70 years, you can pretty much usually assume that the copyright of anything you find on the internet is usually still live. And you should seek permission from the copyright owner to use it. So don't right click and copy. Another one which is kind of connected to that is that people think if you change, well, 30%, I hear different percentages. If you change 10%, if you change 20%, then it's not an infringement. And that's not true. The percentage of unauthorized copying is irrelevant. The legal test for infringement is not about the quantity that's copied. It's a qualitative test. So it's about whether a substantial part of the copyright has been protected to the point that you can still recognize it as coming from that original work. So it doesn't matter if you just tweak that and just tweak that, then that's enough. That's just simply not how it works. It's a complete misunderstanding. And another really important point I think to make is that copyright is infringed by the act of adapting a work. So an adapted copy it's known in law as a derived copy, and claiming ownership of a derived work is also an infringement of moral rights. So the only safe option is to create something completely new and original yourself from scratch. Don't tweak something that's already out there. Again, leading on from this, most people believe that if you credit the original author or add a disclaimer, this is a good one, no copyright infringement intended, that they think that they're off the hook, but it simply won't protect you from legal action. If you have copied it without permission, then that is a copyright infringement. Now, practically, in reality, if you've credited it back to the author, then usually commercially they're usually just quite happy that their work's getting promotion and so on, but technically they still could legally sue you if they wanted to. The law doesn't care about disclaimers and credits. If you infringe, then you're liable. It's as simple as that. But I haven't seen a case yet where someone has acknowledged an original author and then been sued. That virtually never happens. It's usually just where you take somebody's work and don't credit them. But yeah, you need to be quite careful about things like that. Another very common myth that I hear that gets people into trouble frequently is the belief that they can freely use their own name. So people think, well, my name is John Lewis, so I can open a shop called John Lewis and I've got a defence. Now, it is true that in trademark law, one of the statutory defences to infringement is use of your own name. But first of all, that only applies to individuals and not businesses. So you can't be John Lewis Limited and then claim the defence. And it's also subject to the exception of whether you've set up that business in accordance with honest business practices. Now, if there's already an established chain of shops called John Lewis, it's not in accordance with honest business practices to then set up another shop with the same name. So if my name was genuinely Carrie McDonald's, then that doesn't mean I can open a burger joint called McDonald's and claim the own name defence, because there is already someone actively trading with trademark rights in that field. So the key point really is just that if someone has trademarked your name in a field, then you can be blocked from using your own name commercially. And they can also have an actionable claim for passing off if they can establish that it's misleading customers. A really famous example in the UK is the British fashion designer Karen Millen. She sold her company, but later tried to launch a new brand under her name, and she tried to claim that defence. But the court ruled that she can't use her own name for fashion because it's a registered trademark, which is now owned by her former company. So please don't make that assumption. This is myth number 10. The one that I hear a lot is that IP protection costs an arm and a leg. Now, the reason I say this is a myth is because, first of all, there is a perception that it costs a lot more than it actually does generally. Also, patents are expensive. There's no getting around that. But most businesses, it will be trademark and design protection. and or things like copyright protection, protecting your confidential information, protecting your trade secrets. And those are all internal processes that won't cost you anything. It's about having the knowledge and implementing the processes properly. Now, again, you can do, like with any field of law, you don't have to have a lawyer. You can do it yourself. You can register your own IP rights yourself, in which case you would just be incurring the official fees. But I think really my point here is that the costs of not protecting your IP just pale in comparison to the costs of actually that they actually cost. Because if you try and save money by doing it yourself, then obviously you can avoid the legal fees for that. But you don't know what you don't know, and so I generally would advise against that. But you can do something on a budget, which is better than doing absolutely nothing at all due to this perception that it's too expensive. And I think a lot of people I see, startups, time and time again, they find the budget for a designer to create a logo for a name they don't own, but they can't find the budget for a trademark application to actually legally own that name as an asset. And it feels to me that there's just a misalignment of priorities, which is probably due to just a misunderstanding of the importance of IP. But I think what this relates to really is this kind of other myth that I hear sort of banded around, that if you can't afford to sue someone, then why bother protecting the rights? And my answers to that are twofold. And the first of all is that registering the IP is a deterrent, a strong deterrent effect. Infringers and copycats go after low-hanging fruit. If they know that you have no registered IP, you're an easy target. It's like walking down the street and seeing a window that's wide open. You're just an easy target for a burglar, basically. If you've got registered IP notices, it's a clear signal to competitors that you take it seriously and there's going to be legal consequences if they infringe. A bit like putting a security system in your home and in your IT systems and so on. Now, most infringement cases don't go to court. That's the reality of it. A well-crafted cease and desist letter, a negotiation usually leads to a favourable outcome where they settle, they offer you licensing fees or, whatever you need. So yes, IP litigation has a high cost, but the fact is that most of the time you can avoid the need to litigate, A, by deterring people in the first place, and B, by being able to send a cease and desist and put them on notice and they immediately back down. The second point is that there is IP assurance available, which most people just have no idea about when they're setting up their businesses. They have product indemnity insurance and various this and that and the other. Nobody seems to have heard about IP insurance, and that is available to protect businesses and individuals against the cost of enforcing their intellectual property and against being sued for infringement. So again, it's a well worth a policy, of taking that out. And obviously the premium will depend on the size of the business and the complexity of the coverage that you need, type of right, risk exposure, the industry, and geographical scope of coverage that you need. But it's like driving a car with no car insurance to me. It's just something that's so valuable to have in place, and it will completely mitigate the costs of suing someone or being sued. Most people are just not aware of it. So yeah, a bit of homework for any of you. If you just take the time to reflect on what is it you care about most in your business, what would hurt your business the most if someone copied that element? Was it the name? Is it the reputation you've built up in your name? Is it some secret know-how you've got? Is it your customer database? Is it your supplier list? What is it that makes you stand out? Why would I use you rather than your competitor? That's the bit that is valuable to your business. And then research what IP rights there are around protecting those assets. So just reflect on that, and you'll be surprised, I think, what IP assets you have that you don't realize exist. And then you can start planning around, well, what of these assets can I protect for free by just having proper internal processes and training for my staff? What am I going to actually need to spend something on legally? When do I need to do that? Just start formulating a very basic IP strategy and every bit of time that you invest in making yourself more knowledgeable about IP will pay you back in dividends. It's not time wasted, I promise you that. But of course, if you want professional advice, then here I am. Here is my LinkedIn QR code. I hope that works. I haven't tested it recently. That should link you to directly to my LinkedIn homepage. But yeah, if anyone's got any questions, then feel free to drop me a line.
Brilliant. No, thank you for that. I'll make sure we include your links as well on the video and description and such. And when I share it on online, that was really interesting. And
it's just a quick trot through.
Yeah, well, of course, yeah. I mean, it's one of those areas where, of course, this is your specialism, and you can obviously simplify a very complex, or what can be a complex area for many people. I think it was really interesting as well to well, everything that you just talked about there, some of the myths around this topic, but there's a couple of things I want to draw out which I think are important for cybersecurity, info security practitioners, especially, who might be watching this, but it's relevant to everyone. But in our industry, we often talk about protecting your informational assets. And I'll be honest with you, it's when it comes to IP law or intellectual property or copyrights, it's very rare that I actually see on people's risk registers this topic. It's just not considered as a threat or vulnerability. We hear quite often about cyber attacks. You see that on a risk register. We'll see on there that talks about risk of floods and fire and pandemics, but it is rare to see intellectual property being discussed on risk registers and in relation to companies' informational assets.
And yet the value of their IP can be the biggest part of the valuation of an entire business. Far more than take, for example, Coca-Cola. Their physical assets, their factories, are worth X. Their intellectual property, the value of their IP is that 100 times fold. And it's often the case where a lot of businesses who don't have a lot of physical assets, the value of the business, if they ever sell it or anything like that, is in the IP.
Yeah, I mean, it's interesting, isn't it? And when you hear business coaches, especially, they'll ask questions like, what's your USP? What is it that makes you unique?
Protect that.
Yeah, that's it.
Because what happens with investors as well, or when people try to sell or raise finance, investors, no one wants to buy something that you can just copy. And if you don't own it, then you can be copied.
Yeah, and genuinely, it's interesting that story that you told earlier about the logo, because that actually happened at an event that I was at. Very similar. Really? Yeah, very, very similar. We had invited someone to speak at an event, and they got up on stage, did a phenomenal talk about, I can't even remember, it would have been cybersecurity clearly, but they got up on stage and a little bit like you did, they said, and here's my details, here's my information, here's my website, come and talk to me after the event if you're interested. And then someone came up to me and just said, that speaker you had, phenomenal, I've got a bit of a problem. And I was like, oh, what have they said something to upset you? To cut a long conversation short, they just said, we've just paid a designer £15,000 to design us a logo, and she's got exactly the same logo. And I was like, how did that happen? They went, we're going to find out. Yeah, good question. We're going to go and find out, because we just chatted to her and found out that she's used the same designer as we have. And I'm like, wow, that's an incredible situation.
The most common one that I see is people using things like Canva for creating logos. And this is an issue that comes up frequently. Now, obviously, Canva is an epic design tool, but it does present IP traps that most businesses are falling into. And that is that you are, as a user, you are granted a non-exclusive license to use that design. So that doesn't mean you can ever own it. So yes, it's a free way to get a logo, but it means you've got no rights to it. So you might be allowed to use it on, you'll have to look in the terms and conditions as well, but permission to use on websites, social media, business cards, but you can't ever stop anyone else having the exact same logo. So my advice is always that if you care about owning something, don't use AI or these kind of common design tools. Pay a designer and make sure that part of the terms and conditions are that you will own the IP at the end of it.
That's great advice. And one of the stories that you told me, again, I think you'll do this more justice than I will, but about a disgruntled employee who they essentially registered and took their employer's IP. Is that right?
Yeah. So he was sacked, and it was all very acrimonious between them. He knew that the business owner had no registered IP, so he went off and registered it all, and then issued the business owner with a cease and desist to stop using their own name.
Wow.
In that situation where you've got earlier common law rights, we were able to wrestle it back, but it was still a whole load of litigation that could have been avoided if they just done the actual registration themselves at the beginning. So it's kind of that saying, a stitch in time saves nine. It's literally the case with IP.
Yeah, no, absolutely. I think
don't spend 10 grand fixing something that would cost 1 grand to get right in the first place.
Yeah, no, I completely agree. So there's lots more to unpack. You and I will continue this conversation because there's more things that I want to talk to you about. But for everyone else, I hope that's been useful, not just for information security practitioners who clearly need to go back and look at your risk registers and say, do we have any risks around intellectual property rights and copyrights and trademarks, etc.? If you do, if you don't have those risks, then you need to add them. If you do have those risks, clearly you need to be speaking to an expert like Carrie, who will be able to assist. But let's you and I continue this conversation. For everyone else, you can go and get on with your day and do the homework.
Don't have a panic attack.
Go and don't have a panic attack, because they've got you now in their corner to assist. But anyone who's a business owner in any way, shape or form needs to go and assess this. But
before it's a problem, don't wait till your kitchen's on fire. That's what I always say.
Absolutely. Don't wait until the kitchen's on fire. And again, very selfishly, talking to information security and data protection practitioners, that's what we live and breathe. We're all about risk management. The key question is do you know enough about this particular risk? If you don't, speak to an expert. And I'll leave it at that. Carrie, let's you and I continue this conversation. To everyone else, don't forget to, I'd love to hear your comments, your thoughts, your insights on this, maybe your experiences as well. Give this video a like, a comment and a share, and we really appreciate it. Carrie, let's carry on our conversation.
Thanks, Gary.
Thanks.